What's up, folks? We're just waiting on Ileana. Fashionably late, as usual. You can't see me, but you can hear me. Thank you. The following has been a message brought to you by the Church of Jesus Christ of Latter-day Saints.
Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer Podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
Good morning, everybody. This is Omar Serrato with the Tilted Lawyer Podcast, joined by Ileana Clone Rosa. For the first time in a couple of weeks.
I know.
It's been a couple of weeks. Every now and then, Ileana has to take her own mental health breaks. And we didn't do a show last Friday, you know?
No.
I had to take my own mental health. I was like, you know what? I'm not doing it today. And I didn't. But there's been a lot that's happened since this Karen retrial, obviously mistrial and all. Last time that we did a show, we were discussing this case. in our opinion, was, oh, there's no way they're going to look. They're going to come back after the weekend. They're going to figure some things out. They're going to come back refreshed. But God damn it, it's like a couple hours later. It turns out that if you believe the affidavits of the defense attorneys, where they say that jurors had reached out to them and said that they were unanimous on not guilty on second-degree murder. They were unanimous, I think, on count 2, not guilty. They were stuck on count 3, which is an odd ruling. But there was a lot of lead up and speculation leading up to the jury forms, the jury slips. There was this note that was respectfully written saying that, look, we are deeply divided in our respective positions. And if we were to give in, it would cause either side to violate their moral conundrums. And then the judge, well, I'm not going to make you do that. I declare a mistrial. And that's where we went. A lot has been made about, well, she didn't even poll the jury. Like she 100% could have and perhaps should have polled the jury. But in Massachusetts, it's not required that they do. There's a lot of misinformation out there stating that she was supposed to poll the jury. That's not the law in Massachusetts. I did my own independent research. There's case law that says that specifically the judge doesn't have to do that. The question is, if what the defense is saying is true, in that they were sold on acquittal on the major charges, then what right does the defense have to retry the case without violating constitutional principles of double jeopardy? So there's that. I should be rolling the intro right now. I normally do like my big teaser, but I just did the intro right off the bat. So here we are. What was your opinion, Ileana, when you heard hung jury on that fateful day a couple of weeks ago, whenever it was?
I was a little bit surprised. I was a little bit, I guess, happy. I don't know why. I felt that her attorneys did a good job. But then when I started reading about pulling the jury and all that, I was like, oh, like, I don't know.
Did you hear after the trial, there's been like this,
the jurors coming out? And
no, it's more salacious than that.
Oh.
There's been allegations that Alan Jackson was having an inappropriate relationship with Karen Reed.
Oh.
And there was a picture that came up on our Discord. And then the question was, what was the question? Oh, yeah, it was, hey, is this normal? Getting this close with your client? And then there's pictures. And then there was this picture here. I don't know if you saw it. This is after the trial. Alan Jackson, this is Karen Reed, and he's embracing her like that. This is a picture of Mr. Jackson and his wife looking really, I mean, to be fair, she could just be hangry. But this is after trial, and there's been allegations of a misconduct with this relationship, Reed and Jackson, to which I responded, yeah, no,
that's not normal.
that looks like a boob grab.
Yes,
That's
it does,
not
definitely.
appropriate attorney-client.
Were they like at a bar or something? It looks like they were celebrating.
I think they were getting out of a car and effing around. Maybe he had a little bit of alcohol in the system. I don't know. He's getting a little handsy with his client. Maybe he's just
a little.
I mean,
I don't know.
all that aside, the legal aspects of this case. Here's what it is. If it's true that the jurors were going to acquit on the major charges in the case, and you have the Commonwealth stating that they want to retry the case, does double jeopardy apply? If you can prove that the jurors were really 100% going to acquit her on those charges, the answer is, no, because then double jeopardy would attach. It's just the legal process. The question is, how are you going to go about the process of proving that without polling the jury individually, which I don't believe that you're allowed to do?
That's a good question.
So a lot of this depends on, okay, that's great if that's true, but how do I prove it? Because in that note, it didn't sound like they were in accord. Just that note. And we're going to listen to the video leading up to the mistrial again, saying that, look, some of us are deeply ingrained in the fact that the Commonwealth has proven their case. Others believe that they have not. That was the language. It was very
Yes.
vague and ambiguous. And then you have these jurors reaching out and saying, well, no, actually, we were not really all that divided. We were in agreement on some charges, just not others, not the lesser included. And then you had one other juror a couple of days later on July 10th come forward and say something similar.
Yes.
And then Alan Jackson was like, see, there is some truth to that statement.
But we don't know about the rest.
Yeah, but there's 10 other jurors in there. And we don't know for a fact that all of them would share that opinion. Who was the one defector or multiple defectors? I had speculated that the fact that they use the word some literally could mean one. There was one holdout, and they were trying to be kind and to protect his or her identity and say some. And I thought that there was maybe just one person that was just really didn't like Karen Reed because, I don't know, didn't like her voice, didn't like the way that she presented in court. Maybe he had a bad relationship with somebody that looked like her and decided that no matter what she did, she was guilty. But the evidence didn't support an angry 12 angry men. He was going to turn the entire jury against her. Beach Lover says, what did she say? I think that Reed attorney Hand's video was deemed AI. Oh, was it AI? I don't know. I have no idea if it was AI or not. It was just dropped on our Discord, which is, you know, AI is a scary thing. I don't know what's real anymore, man. I don't know if voices. Well, remember when we try to do our AI voices? I try to generate mine. Like, yeah, that's clearly a robot. Okay, but I don't have the best software. But there's clearly software out there where you could just make new Elvis Presley songs. Matter of fact, I know I'm going off script here. Elvis Presley AI song. Check this out. Oh yeah, it was this one. Tell me this doesn't sound exactly like Elvis. All right.
I wouldn't know the difference.
You told me that was now he's talking about Big Butts. It's the 1990 whatever song. I don't know if you caught that or not. But that sounded good. I would get down to that song, man. It sounded good, man. If you were wanting to emulate Elvis Presley, totally do it.
AA is definitely scary. My husband and stepson went to the Sphere in Las Vegas.
Oh,
and they
haven't been
have
there
some
yet.
robots with AI, and you can talk to them and create conversations. And they said that it was extremely scary how much they can interact with humans and how much alike they are to a human being.
I've seen that robot.
Yeah.
And like how they start saying crazy stuff like, so are you guys ever going to rise up and take over humanity? And then the guy's like, why would we do that? You guys are our friends.
Exactly.
Of course we're not going to do anything like that. You know, secretly plotting.
Yes, apparently somebody that was there asked something similar to that, and the robot just responded. It's like, okay, no.
All right. So let's listen to the actual moment when actually had it here in my notes when the jury the judge declared a mistrial. I have some thoughts about this judge. I didn't like her. I would not like practicing in front of her. Me and her would get in a lot of arguments. I suspect. Well, let's just play the video before I say something. That link, here we go. Before I do that, let me just make sure that everybody could hear the audio here. Hey, chat, let me know if you could hear the audio on this video.
Court is in session. Please be seated.
All right, Mr. Foreman, I am in receipt of your note.
Are they not hearing the audio?
I could hear it on my end, so it should pick up for them. Yeah, they could hear.
Okay. All right, let's resume.
Judge Canoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt.
Here's my problem with Ellen Jackson's declaration. Listen to what she just said and tell me if that sounds like a jury that was all in favor of acquittal on all of the counts except for count 3.
Establishing the burden of proof, establishing the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service.
Does she remind you of any judge in a courtroom that you work at that used to practice or around here until about a couple of years ago? You know who I'm talking about? She had like this kind of look and almost those exact mannerisms and that same speech pattern. It's not the same judge, but she was mean like that.
Yes.
Our judge is a lot meaner than her. I'm
Yes.
just saying. She reminds me of her.
Okay. If I'm thinking of one, I don't know if the same. If
You don't
it
have to
is-
name it, but if you're thinking about
Yeah.
it, chances are
Yes.
it's the one. Not that I didn't like that judge, but she scared me to death. She was like one of my first judges that I've ever practiced. And of course it would be her. And she would just rip me a new one whenever she felt like it,
Yes.
honestly. So, all right. The problem with this whole thing, these motions, is all it takes is one juror to say, no, we were not
Yep.
all in favor of acquittal. And then the entire motion is moot at that point. And then, and really the standard is really that low. All it just takes is one. And then the people, the Commonwealth are going to be able to retry the case. Let's finish this.
All right, so the court, please.
All right. We don't need to examine that further. So that was the motion. That was the motion. I heard Emily D. Baker give some thoughts that the jury should have been polled. And maybe they should have, but it's not required
Yeah, if it's not required.
in Massachusetts to do that. It would have been a really good thing to do.
Yes.
It would have been really smart to have done that.
It would have saved some time for everybody.
Yeah, but the fact that she didn't do that, does that automatically invoke double jeopardy? No.
I don't think so.
Here's the law, just so that we're all clear, all right? And I'm not just talking out of my ass. In Massachusetts, the procedure for declaring a mistrial in a criminal case where a jury trial involves several key considerations and steps. A mistrial may be declared when there is a manifest necessity for the act or when the ends of public justice would otherwise be defeated. This means that the trial judge must determine that continuing the trial would not result in a fair and just outcome. That comes from Elder v. Commonwealth 385 Mass 128. The trial judge has the discretion to declare a mistrial. The discretion. And this decision is typically made after considering various alternatives. For example, in some cases, the judge may consider curative instructions, in which case the judge did give curative instructions. I don't know if they were the best instructions, but she gave instructions to the jury or a voir dire to assess potential prejudice before deciding to declare a mistrial. That comes from Levitt v. Commonwealth, 393 Mass 444, and Commonwealth v. Bryan, 476 Mass 351. The judge must balance the defendant's right to have their trial completed by a particular tribunal against the public's interest in fair trials designed to end in just judgments. Elder v. Commonwealth. And you got to understand too that this law literally dates back to the 1500s when they were doing the Salem witch trials. It's literally almost basically the same jurisdiction. So this is case law that's been developed longer than America has been a country, the United States. That was Elder v. Commonwealth 385 in the same case. So if a mistrial, now notice in those cases, and I'm not reading the cases because it would take, I mean, honestly, this is like a week seminar. But none of that language directs a judge as a requirement to poll a jury. They give them limiting instructions or further instructions. They did that. And so here we are. So if a mistrial is declared due to a deadlocked jury, this is considered a manifest necessity. There was a declaration of a deadlocked jury, and double jeopardy principles do not bar a retrial. That's from Fuentes versus Commonwealth 448 Mass 1017 and Ray versus Commonwealth 463 Mass 1. However, if a mistrial is declared over the defendant's objection, this part is important because the defense was not given an opportunity to object. So this is why this is going to probably going to the Supreme Court. Because just because this is the law does not mean that it's necessarily covers all constitutional bases. Then the question becomes, was the judge required to offer the defense the opportunity to object? Because the alternate argument to that is the judge doesn't have to give legal advice. They could have objected at any time. The fact that they didn't and were silent acted as a waiver of objection, to which they didn't make, although them being powerful, experienced attorneys would have known that they had the right to do that, and they just didn't object. They just let me continue with the mistrial. And sometimes that happens in family law. I know, look, it's not, maybe 50% of the times, the objections that I make, the judge doesn't ask me for my objection. I just make it.
Yeah.
And it's a fair point to make if you're on the Commonwealth side saying, no, they had the opportunity to object. They just didn't. They knew, they saw where this was going. And plus they could also maybe argue that they already objected the first time, which resulted in further instructions from the judge and the like. Now I know most of the people listening to this stream that watch this video are going to be wanting or in favor of the defense. We have some super chats. Let me, before I get too far into this, sarcasm. Why didn't the jury ask how to complete the form if that was the case? I'm not so sure that the form was all that big of an issue, because I think that the original forms that I saw were modified to more aptly fit what the defense was asking. And I'll go over that video because that's a great point that I wanted to discuss, because that is highly relevant because I mean, it all led up to this mistrial. Hey, Brad is in the house. What's up, Brad? IT goatee. He's IT goatee is like my IT guy when Dominic's not around.
Okay.
Not officially, just he's the guy that I go to. He's done a couple live streams with me. He's got his own YouTube channel. He's the best. Because I got whiskey on my face. Okay, so before, where was I at? I was reading stuff.
Yes, about the forms.
All right, so if they talk about what is considered manifest destiny, that's basically when the jury says that we're deadlocked. And I talk, so however, if a mistrial is declared over defendant's objections, that's where we're at. The judge must have given defense counsel a full opportunity to be heard and must have considered all reasonable alternatives before making the decision. And that is where the argument lies, isn't it? So was he given full opportunity? And what does full opportunity even mean? Because if I was the judge and I was trying to cover my ass, but look, this defense attorney objected over 10,000 times in the course of 2 months. He's well aware of the rules and how to make objections. He's been, he represented Karen Reed extraordinarily well. He's well-versed in the law. He knew what was available to him. The fact that he didn't object when I was declaring a mistrial, I should not have to ask him directly if he wished, because I don't even think she asked the people at that point. She just declared it.
But at the same time, when you're reading the law, it's saying that she must give the opportunity, or the judge must give the opportunity to the defense.
Right.
It's not talking about objection. So
So if you
was
recall,
she the one that needed to do that question?
yeah, and so, but she did
Mhm.
not when in that video,
Mhm.
but prior, I think on Friday,
Oh, okay.
she asked the Commonwealth, "What do you guys think about declaring mistrial now?" And they had
Mhm.
argument, and then the defense was heard at that time,
Mm.
and then they broke for the weekend, came back, deliberated for like an hour, and then declared mistrial. So the question then becomes, was that
Enough.
yeah?
Mhm.
If I was the defense, I'm saying no, it's not enough. I should have
course.
been heard. I wanted to take. I would have. I'm assuming that Mr. Jackson would have requested a poll of the jurors to see where they're at. What is the hangup? I need more information. Which would have been a fair request. And I
Yes.
think that had that objection been made, I don't think that the judge would have said, no, I'm not
Mhm.
polling anybody. I'm just done. Because that would have been ridiculous.
Mhm.
So, all right, we've been doing this for a couple of months. What's it, all right, so where are we at? On count one. Give me the numbers.
Yes.
What's wild to me is that I've heard other law tubers out there suggest that they know what the polls were, what the numbers were.
Oh,
Some were suggesting it was like 10-2. Some were suggesting it was 8-4.
based on
I don't know where they got that from.
I know.
But now you have Jackson saying, no, it was 12-0 in favor of acquittal on the major counts. I don't know what to believe. And my only point is, if there's one juror that comes forward and says that affidavit is bullshit, motion defeated. It's that simple. It really is. Let me continue with this. So in summary, the procedure for declaring a mistrial in Massachusetts involves the judge's careful consideration of whether continuing the trial would be unjust, the exploration of alternatives to a mistrial, and ensuring that the decision is made in the interest of both the defendant and the public justice. This process is guided by the principle of manifest necessity, which is an ancient legal term, and the need to ensure fair trials. And again, they cite to Elder v. Commonwealth, Ray v. Commonwealth. If you're wondering where I'm reading this from, it's literally from Lexis, my own independent research. I figure that I pay for Lexis. I might as well use it for something useful. So
It's not cheap.
yeah, here's a question. Is it required that the judge poll the jury prior to declaring a mistrial? Is it required? No, it is not required that the judge poll the jury prior to declaring a mistrial in a criminal case in Massachusetts. The decision to poll the jury is within the discretion of the trial judge. And you should put those in bold underlying letters. Discretion means basically if you're going to get one over on appeal, it's going to be because of an abuse of discretion, which is really hard to prove. And there's a case in Commonwealth v. Nettis, 418 Mass 715. The court upheld the trial judge's decision to poll the jury after a juror indicated dissent, leading to the declaration of a mistrial. The judge acted within his discretion in setting aside the improperly recorded verdict because the jury had not agreed unanimously. Also in that case, similarly, in Commonwealth v. Reeves, 434 Mass 383, the court noted that a judge's handling of the jury poll does not necessarily affect the validity of the original verdict if the verdict had already been recorded. Which is not helpful because I don't know if their verdict was recorded in an official way. But furthermore, also in this other case, Commonwealth v. Herbert, 379 Mass 752, the court found that a mistrial should have been declared when a juror did not agree with the verdict, but the judge's failure to poll the jury before declaring a mistrial was not deemed an error. This indicates that the polling the jury is not a mandatory step before declaring a mistrial. So, in sum, there was no fast rule that requires a judge to poll anybody. It's just been ruled in other cases that the judge's failure to poll the jury was not deemed error by appellate courts in Massachusetts. That's all.
Yes.
And that's all you really need to come to the conclusion that it's not a requirement. Furthermore, so while polling the jury can be an important step in ensuring the unanimity of a verdict, it is not a required procedure before declaring a mistrial in Massachusetts. This decision rests with the trial judge's discretion based on the circumstances of the case. And again, they're referring to the Nettis case, the Reeves case, the Herbert case, and so on. All right. So then let me ask you this. If the jury, after a mistrial has been declared, makes contact with the defense attorney to indicate that they were unanimous in favor of acquittal on the major charges, but hung on lesser included charges, does it trigger a defendant's protection against double jeopardy? That's the appellate question, isn't it? And wouldn't you know it, the law is not firmly decided one way or the other. But this is what the law says. The double jeopardy clause generally prevents a defendant from being tried more than once for the same offense. However, there are exceptions to this rule, particularly when a mistrial is declared due to a hung jury. In such cases, retrial is typically permitted as long as the evidence presented in the first trial was legally sufficient to support a conviction. Now we're getting into directed verdict stuff, which I've never actually seen a direct verdict work in a criminal defense. I've heard of it. I've just never seen it in practice. It literally means that there's no reasonable, viable way that any jury could have possibly come to that conclusion. Bullshit. I'm taking it out of the hands of the jury and declaring my own verdict. Really what that is, which is such a high standard. I've never seen it happen.
Seen it, I think, in movies.
Yeah, and sure. I can't think what the movie would have been.
Yeah.
And I'm a big fan of lawyer movies. By the way, on our Patreon, you got to come with us when we're doing our movie reviews. We do these, well, we don't do them yet, but we're going to do our movie reviews, and we're just going to watch a movie with our Patreon subscribers and share our thoughts. No research needed. We're just watching movies. I'm pretty sure you're not
or
it's going to be like I don't know, man, like 12 Angry Men would be a real good one. Stuff like A Time to Kill, Samuel L. Jackson, Matthew McConaughey. What about The Lincoln Lawyer? Everybody likes McConaughey and that portrayal of stuff. There's The Verdict.
Yes.
My favorite actor of all time, Paul Newman, 1982. Hell, Better Call Saul is always up for anyway, I'm getting off topic. People don't like when I do that. So where was I at? The fact that the jury was unanimous in favor of acquittal on the major charges, but hung on the lesser included charges, does not change the applicability of double jeopardy protections. The key consideration is whether the mistrial was declared due to manifest necessity. The judge is going to say, of course it was, such as a deadlock jury, which allows for a retrial. And then they quote cases, Commonwealth versus Fem, Daniels versus Commonwealth, Commonwealth versus Medina. You guys could all look those cases up. Additionally, the communication from the jury to the defense counsel after the mistrial. You know what? I should just share my screen so people know I'm not making this shit up. Share. All right. Well, that didn't have the desired effect, did it? Okay. Did I already get past? Yeah, we already got past that one. All right. So the fact that the jury is unanimous, we got past that one. So additionally, the communication from the jury to the defense counsel after the mistrial does not alter the legal standing of the mistrial or the ability to retry the defendant. The court's decision to declare a mistrial due to a hung jury remains valid, and double jeopardy protections do not bar a retrial in this context. So if they can prove that it really was 12-0, if that can be proven, I don't know how they're going to do it, because the jury literally has no obligation to talk to anybody ever again about this case. Then I guess, double jeopardy can apply. It's not really been a thing. It's not really a thing in case law right now in Massachusetts. There is not a fact for fact scenario such as what we have with Karen Reed right now to give us any direction. So we're left with these legal principles to decide what to do. And if you were ever wondering and wanting to study law, or we had designs on becoming a lawyer or wanted to do this for a living, this is kind of how it works. This is how the law is advanced. We come up with new areas of law not previously explored, and we seek appellate review. And then these cases, the outcomes of these cases, drive what the law is going to be. And this body of law has been probably developing for the last 1,000 years. If we're going back to imperial law, if we're going back to what did they call the law in the UK? That's where American law comes from.
Yes.
I don't know. I'm not gonna try to remember my history class. But just it's thousands of years old. So, all right, what is the threshold for the defendant proving the evidence was legally sufficient to support a conviction in the above scenario? That's an important question because it goes to what we've been talking about. So the threshold for determining whether the evidence was legally sufficient to support a conviction when a mistrial due to a hung jury has been declared in Massachusetts is whether, after viewing the evidence in the light most favorable to the prosecution, basically everything that assuming that everything that they said was true,
Yes.
and there's not evidence that would defeat it, and we're giving it in the light most favorable to the prosecution, can a jury decide that Karen Reed was guilty? Any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt, which you and I don't agree on its merits. But if I were to view this as like, let's just assume everything the Commonwealth said was true,
Yes.
and what the defense said wasn't enough to overcome it. Can a jury found enough? Yeah, but they decide that like at the pre-trial stage, preliminary hearing stage, the grand jury stage in the Commonwealth.
Yeah.
So it's already been decided that yes, she would be guilty if that's why we have a trial. So that's already basically done. So this standard is consistently applied to Massachusetts case law. For instance, in Taylor v. Commonwealth, it is stated that the Commonwealth must have presented evidence legally sufficient to support a conviction at the first trial, or jeopardy terminates for state law purposes, and retrial would violate double jeopardy principles. Similarly, in Pena versus Commonwealth and Collazo versus Commonwealth, affirmed that double jeopardy principles do not bar a retrial after a mistrial due to a hung jury if the evidence presented was legally sufficient. So it's a really hard thing for the defense to overcome, especially when we're already there because it's already been determined that that's a thing. The case Penny versus Commonwealth further clarifies that the evidence must be sufficient for a rational trier of fact to find the defendant guilty beyond a reasonable doubt when viewed in the light most. That's all a lot of the same thing. So the threshold is met if the evidence, when viewed in light most favorable, supports conviction. That's it. That's it. So those are the rules that we are navigating. Those are the rules. Yes, I'm drinking at 11:30 in the morning. It's Friday. I'm supposed to go on vacation. Well, not vacation. I'm supposed to go away for the weekend. So I'm pre-gaming it, I guess.
I'm the opposite. I'm trying to fall into rhythm after having a couple of days off.
Oh,
So
gosh.
hard getting back into.
By the way, I want you to know that our audience was really interested in whether or not I provided sandwiches for you or not,
Oh yes, I forgot to ask you.
which I did. They were in the fridge.
They're in the fridge.
I had them delivered to my house last night, just in case.
Thank you.
Yeah, and then I was like, hey, Dominic, why am I bringing her sandwiches, man? Like, how come she can't bring sandwiches to me? Should I have her bring donuts or something? Coffee?
Well, I can do that. I'll just be maybe an
Later.
hour late. Yeah.
Okay. So where was I at in my meanderings? Okay, I wanted to pay particularly close attention to this because not that it really matters much in terms of the veracity of the case, but it's just the judge's, her predisposition was very off-putting.
Yes. Yes.
I don't know if she's more favorable to the Commonwealth or to the defense. I don't know. I just think that she was just generally, this was just her attitude. I've been in front of judges like that before.
Yes.
There's not a lot you could do about it, honestly. I mean, you could fight back and forth with them and argue, and they're the ones holding the gavel. What are you going to do? You could bring them up on appeal, but, do you got clients that want to pay for an appeal? And even so, do you, I don't know, man. But this is the judge. I just thought it was really interesting, this portion of it, when the judge was literally like, I'm too tired and I'm not going to address this. And then they talk about this. And then she yells at Karen Reed for like smiling. It's like, I feel like if I was a defense attorney and my client got yelled at by the judge for smiling, I would have something to say. Whether or not I would say it or not, I'm just saying it would piss me off.
Yes.
You have to keep a level of, I find that once I pass a certain threshold, I should just not say anything. Because whatever next comes out of my mouth is not going to help anything. It's going to only serve to serve my ego, my anger, my need to just say something, get one over like I'm 12. But this,
That's what emotional intelligence is all about.
Well,
Knowing
someone-
that threshold, knowing
Yeah, I would
when
agree.
to stop.
Some days I have better emotional intelligence than others. But just let's take a listen to this. For the simple proposition that I thought that the judge in this case was a dick. And it sucked. Not that she didn't, you know what, honestly, she did an okay job during the trial. She was
did
just
an okay
off-putting.
job. It was just her attitude. Yeah. I mean, to me, she really didn't want to be there. She didn't want to be the judge in this case.
I disagree. I thought
Yeah?
that she loved being there.
Well,
I just think that I think that she loved being there. I just think that she has a low energy threshold and she got fatigued and you know, what judge have you ever seen not want to be like the center of like a major case like this? Most judges, when you see in these kinds of cases, are on their best behavior.
yes.
Except for that one judge with the Parkland case. Remember that one where she's yelling at attorneys and yelling at public defenders? And what was that case, man? When that one attorney brought a motion and she was yelling at him and it's like, you don't know. The one comment, man, one attorney made a statement like, Your Honor, if you were pregnant or if you had children, you would disagree. It's like, you don't know if I've ever had children. You don't even know if I'm barren or not. You don't know. And then she's
I
like,
remember.
told him to go sit in the corner. Remember that
Yes.
one? Most judges are on their best behavior. I think that this judge, she liked being there. I just think that she got really tired along with everybody else. Hangry. I feel like here, you want to know my honest opinion? If you were a judge
Who get hungry?
in 20, 30 years, if you were a judge, I feel like this would be you.
Oh my. Oh no. Well, they need to keep me. At least when you're a judge, you can
Keep
have
you fed?
snacks and stuff like that. Yes. Just have my snacks close by and I'll be happy. But I don't know. I felt like she didn't want to be there, or if she wanted to be there just for the, I guess, the attention or having a public case, she didn't like the facts. She felt like she was wasting her time. I don't know. That's the
I
feeling
feel like
that
I feel that, but I feel like when you're on display like that, you just go fully into whatever your personality is. Whenever I've been in high profile cases, not that I've ever been on like a TV case or not, but whenever I've had like, I've sensed the moment and I know that there's a lot of people watching, I usually turn into like super Omar, like whatever drama, whatever persuasive skills, whatever argument, public speech skills I have just goes on steroids. And I just put on a performance. I pretend like I'm in the movies and I'll give this speech. I've done this in child support cases. And so I just know me.
That's usually what happens to me. That's why I guess most people like don't know me when I'm in the courtroom.
Yeah.
Because that, I don't know, that flame comes when I'm there. Like when I know I need to do my job, and outside of the courtroom, I'm
For
just
you,
like,
for sure. Yeah, you're
I'm
not
just like,
to be bothered, but unless somebody pokes you, and then it's like, all right, and then it's like game on.
yes, exactly.
This week in court, I literally said that somebody was properly blitzed. It's like, Your Honor, I don't need a blood alcohol. We got a video, and she was properly blitzed,
Oh, God.
slurring her words. She was at least 0.24. You can't tell me otherwise. Nonsense. But I feel like I was going that because the other attorney was making ridiculous arguments. Never mind. So let me, all right, before I get too far off, let's,
Yes.
this interaction piques my interest. They're arguing about the jury, the jury slip. What was that, Dominic?
You got to share your screen so they can hear.
Oh, yeah. Let me share my screen. This one. Okay.
Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
You said before you were tired and you needed
I was
to think
tired
about it,
and
but
needed
you
to think about
agree that there needs to be not guilty options for the subordinate charges
No.
under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury is exactly how it always is in Massachusetts.
I ask you a question then. I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Different things.
It's appropriate.
Let me make my argument, if you don't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not
By the way, when you heard an attorney say that, Your Honor, let me make my argument. He knows he's going to get defeated. He's putting on the record.
guilty of the superior charge. And that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide?
I hate when that was the most disrespectful response ever. Okay, are you done? That's basically what she was saying. That was very disrespectful. That would have pissed me off. Something fierce.
That she's not guilty of involuntary manslaughter on that verdict form.
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty.
I have these loving memories of my favorite family law judge who's now retired.
Mhm.
This is exactly her.
Yeah.
This is exactly her persona. I like that judge for a lot of reasons. She taught me a lot by kicking my ass in court or reaming me a new one.
I think that's usually how it goes. Like the judges or even law school professors that really make your life difficult. You end up,
those are the ones you learn from.
yeah, those are the ones you learn from. Those are the ones you end up appreciating at the end.
I hope that judge is doing well. She really was a sweet lady when she wasn't on the bench.
Okay.
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, and apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for their subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like
He's
the court
right.
is directing a verdict of the subordinate charges.
Okay.
Doesn't mean he'll
I
win.
disagree with you.
He's right.
Ms. Tianetti, you've seen verdict slips exactly like this. Okay?
I actually haven't really.
Have you had no lesser includeds?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option. For
By the way, that attorney's been practicing for like over 20 years, I think, unless I'm mistaken. But for the judge to ask, oh, you've never seen lesser included, that's such a condescending comment from the judge. The kind that would boil my blood.
Okay. I disagree with you. All
And
right.
I don't see the
Excuse me. This is funny, Ms. Reed.
Yeah,
All right.
that's
We're
where I
done.
draw the line.
All rise for the court.
Do not talk to my client like that. Uncalled for. Okay.
But they ended up changing the forms after all.
They did. So let's take a look at the forms, which I saved right here. So the actual forms that the judge read from, or well, that were used were these ones. Let me share my screen so everybody could see it. Jury slips. Okay. So these are the forms. Karen Reed verdict slipped on the offense of count 1, murder in the second degree. There's literally a box, not guilty or guilty. Now, it is the opinion of the motion that a jury reached out and said that they were all unanimous, not guilty on count 1. The more that I think about this, it made perfect sense at the time, but the more that I think about it, I'm just skeptical that there's not one juror that's going to come out and say that, no, that wasn't the case because I was the one guilty. Whether or not the evidence supported that or not is a different discussion. We literally ran, last time you were here, 30 days of evidence summarizing it, and we're both of the opinion that there's no effing way that you're going to get to second degree here. How? Why was it even charged with this? That's kind of what we're talking about. And I think that what we had settled on was maybe you could prove that she was driving in while intoxicated. We'll go for that. Fine, sure. She was properly blitzed. Whether she had 4 drinks or 9 or 10 based on the receipts or what, she was no way that she was. I think they did actually take her blood alcohol, and it was something like 0.892 or something at 8 a.m., which means it would have been much higher prior. So this was page 1, page 2. So verdict slip. All right. So on count, it has a offensive count 2, manslaughter while operating a motor vehicle, which I guess apparently they were also unanimously not guilty, but it has a box, but it has 4 boxes: not guilty, guilty of offense as charged, guilty of lesser included involuntary manslaughter, guilty of lesser included motor vehicle homicide. If they were really not guilty on all of that, I don't see how they're hung up on count 3, honestly, which I think would have been a very, if it's indeed the case that they were going to acquit on counts 1 and 2, I think it would have been fair for the judge to go back and say, okay, well, if you're saying she's not guilty in all of these, and count 3 is literally leaving the scene of, well, I guess that's okay. I can see the points. Maybe
No,
she
but-
left the scene of an accident.
But I believe the counts that they apparently were decided, it was 1 and 3. The number 2 was the one that they were
Really?
I think so, from what I read.
Well, we're going to read the motion. We'll clarify
Yes.
that. I'm pretty sure I thought it was they were hung on count 3, leaving the scene of an accident, which would have been the one that I could see where, well, maybe if they thought that the accident occurred before she left, that's what they were hung up on. Maybe.
because I was reading,
Because it literally says leaving the scene of an accident resulting in death. But you're safe, Ileana, because we're going to read the actual motion where they're going to say exactly what it was.
I know I was reading this at 4 a.m, so I don't.
Why were you up at 4 a.m?
As my child that decided to wake up at 4 a.m. to talk and then stay up for about 40 minutes and then go back to sleep.
That's my daughters now. We're going through this stage where it's
Yeah.
like we used to have this lock on the doors where it's like for their safety so they
Yes.
don't fall down the stairs. You know, they couldn't get out of the room, but like, okay, what if they gotta go to the bathroom? They're like 5 and 4 now. Maybe it's the time, but now it's like, all right, 1 a.m., at 2 a.m., at 3 a.m. Dad, I went potty in my diaper. It's like, why did you go potty in your diaper? The bathroom was right there. Dad, the stars turned off their little nightlight.
Yes.
After 3 a.m., I stopped responding apparently. And so like I'll respond at 1, 2 when I'm barely going into sleep, but at 3, I was just dead. And then my wife takes over. And so
At least you have somebody,
a teammate.
Yeah, a teammate there with, I mean, yesterday was just, both of us were woken up at 4 a.m. and we're just like looking at each other and she's just happy sitting there like, hey, let's play. I'm like, no. So I started
Why
reading.
don't you go play by yourself?
No.
All right. So we're gonna get to the bottom of what count that we're officially hung up on according to the motion. Let me get back to here. Y2K Survivor says, I believe a 4th came forward. It was on the 10th, there was a filing.
Mhm.
And I'm gonna get to that. Y2K, I promise. IT Goatee says they have 3 affidavits. Yeah, I'm gonna get to all of them. I don't want to read the entire motion because that's, I'm sure people have read it. I don't think I need to have this screen open, do I? Okay. Let me get to my next thing. I did the research thing. So here was the formal motion to dismiss. And the copy that I have is the official conformed copy that was actually filed by the court. Not the cleaned up version that you could see on other websites, because I just don't want to risk it being altered in any kind of a way. Look at me being responsible. Okay, let me. How do I share this though? Never mind.
What are you trying to share?
A PDF that I downloaded from
Okay,
the.
go to present.
Oh, I think I figured it out. Or did I? Yes. Is this the same thing that I'm looking at? Nope.
So go to present
Present.
and then go to video file,
All right. Present video file.
and you should be able to see the PDF.
No. I see videos. Share screen. I see Discord. Oh, never mind. I found it, I think.
So manslaughter was the one.
Manslaughter.
Was the one that we
Count 2 then?
I don't know.
Well, we'll read it right now.
I just know that apparently.
All right, go to present again, and then go to slides, and then you're gonna have to hit on oh, the cancel that one.
Okay. Present,
Slides,
slides,
and then your computer.
computer.
It pop up now.
Clearly not.
It's popping up right there to the left. They're processing. There it is. See it on the bottom of the screen where the camera's at? Is that it?
Oh, this? Oh yeah, this is it. Good shit, Dominic. All right. All right, let me get out of this. Okay, so this was the motion that was filed. Is there a way to make that bigger? No. That's right. I think we're just gonna have to make do. All right. So this is the motion. And the motion reads, so now comes defendant Karen Reed by and through undersigned counsel and hereby moves this honorable court. And pursuant to the 5th, 6th, and 14th Amendments. Hey, what are the 5th, 6th, and 14th Amendments? Do you remember?
Especially not by numbers.
I'm just kidding.
And not when I had to memorize 2 different constitutions. So no. For bar exams.
That's Ileana flexing. When I passed the bar, all I had to remember was American law. She had well, technically it is American law, but Puerto Rican and the Constitution, right?
They have their own constitution.
Mm-hmm. Okay. To dismiss counts 1 and 3. Okay, so they were, you're right. It was count 2 that they were hung up on.
Yeah.
Counts 1 and 3, an acquittal. Against her on the grounds that the jury reached a unanimous decision. Problem's going to be proving that, isn't it? So the ancient right to a jury trial is no more procedural formality, but rather a fundamental reservation of power to the American people. That's taken from Erlanger versus United States. That's a recent case from 2024. June 21? Yeah. Oh. By requiring the executive branch to prove its charge to a unanimous jury beyond a reasonable doubt, the 5th and 6th Amendments seek to mitigate the risk of prosecutorial overreach. Okay. Prominent among these reasons, colonists, I'm not going to go through that. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. The double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. I'm curious how they're arguing this in light of the law that we went over, which is my own legal research, honestly. So the clause guarantees that the state shall not be permitted to take repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, or okay. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed or error or otherwise. Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the 2nd degree, given the central importance that acquittals have held in our criminal justice system for over hundreds of years. The defense respectfully submits that the jury's unanimous agreement precludes reprosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. I guess the question is, what does the other 9 jurors have to say?
Mm-hmm.
And it's very easy to refute his claim just asking that question, because he's not going to have a good retort. And I don't know what the procedure would be for repolling the jury, honestly. I don't know how they legally do that.
I think that a 4th juror came forward also.
On the 10th.
Yes.
So this was filed on the 8th.
Okay.
There was a supplemental affidavit filed on the 10th, and I'm going to get to that one as well. So to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted. So he's basically asking for them to be polled now, after the fact. He's giving background. Miss Reed was charged on 3 separate counts. We know the whole story. And when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review, but they read it in open court. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. I guess I'm curious about this argument. What duty does a judge have to notify counsel or allow them an opportunity to object? In a trial where counsel, especially at the end, knows very well that they could object at any time for literally any reason. If you don't believe me, go ask Daryl Brooks, because he literally did that, objected at any time.
I know.
For any and every reason, real or imagined. What duty does a judge have to remind counsel that he has the opportunity to object? I guess would be my legal question if I were an appellate judge reviewing this case. And it's not going to be answered in this, just so you know.
Not.
So in short, neither defense counsel nor the defendant consented to the mistrial. And the court never ascertained from the jury whether its deadlock was in relation to one, two, or all of the charges in the indictment. Obviously, there's a couple of issues. One is, I think the court was aware that the defense objected to the mistrial. The last time that they asked, when the judge specifically asked for their input, they objected to the mistrial. So the court was aware. So I guess the question is whether or not that's sufficient to carry over into Monday,
Yes.
which would have been the declaration of a mistrial. Because I think at that hearing on Friday, they basically said that, look, I'm going to give them these new instructions, and then we'll come back and we'll see what we're going to do. And that was the remedy. Yeah. And then more time passed, and then they were at this impasse. And so the judge said, F it, I'm done.
Maybe. I feel like the mistrial ruling, I think it took the attorneys by surprise.
Well,
I mean, she was rather quick to just read the note and mistrial. Like,
I didn't think they were going to, I thought there was no chance they're mistrialing on Monday. Remember, my prediction was they're coming back with a verdict on Tuesday. I don't know, man. If I'm a judge on the trial of the century, what case was bigger than this Karen Reed one? Literally, where you have the world was watching. You have this ready-made for movies situation with police cover-ups and Proctor being suspended without pay for his malfeasance and calling Karen Reed a murderer the day of the mistrial being declared. And you have adulterous affairs with people that are at the home that may or may not have been covering up a murder, according to the defense. You have a dead body laying in the snow by this salt of the earth guy that was taking care of kids. And, you know, by all accounts, a really good guy. It has all the hallmarks of a really good legal movie.
yes.
And it gripped the attention of the American public, the world public, really, because of the accusations of law enforcement malfeasance, corruption, and all of those things. And you're the juror or you're the judge in charge of all of this. Why would you declare a mistrial without going to talk independently with the juror to at least figure something out? It just, you know, I'm not saying that it wasn't within her right to declare a mistrial. I'm just saying perhaps she was quick on the draw. Maybe she might want to run that one back after she had a sandwich or something. Maybe she was just like, look, it's late. I want to go to lunch. I haven't eaten all day. I'm doing the 24-hour fast thing. We're done with this. Maybe it was one of those. But I can't see why it would not have been worth an independent polling of where they're at to gain further insight into where the divide was. Because I got to imagine if the judge knew that they were acquitting her on counts 1 and 3, and the hang up was on count 2, then she could have 100% said, okay, well, I'm not declaring a full mistrial on that. If you guys have full verdicts on those counts, then we could proceed on those counts and declare hung on count 2.
Yes.
That would have been the reasonable thing to do.
And save a lot of time for everybody.
Literally years of appeals and argument and retrying this. Literally, she could have saved the world a lot of time. So was it the right move to declare a mistrial? I don't think that anybody agrees with that. But I can't imagine a world where she knows that the jury is unanimous on 1 and 3, just needs some direction on 2, and says, good, we'll stick with 1 and 3. Because even the instruction that the jurors like, look, we will accept counts 1 and 3 if that's your verdict. You guys just submit us the thing. And we'll proceed with that. And you guys could just deliberate on 2 and figure it out.
Exactly.
Is there any legal questions that we could possibly bring to the attorney's attention to clarify that would maybe better help?
Any instructions?
And then at that point, and then at that point, if it was really these moral conundrums that they were not willing to compromise, then fine, declare mistrial on count 2.
That's why, again, it gives me the feeling that she didn't want to be in this case, because as soon as she had saw the opportunity to get out, she was like, this trial, like, I'm done. Like, I'm not gonna do this.
I don't know, man. To me, the harder thing to prove though is whether or not that was actually the case. Because I know we're making these opinions. Oh yeah, if that was the case, then definitely. Also, I don't know that. Well, I mean, we can never know what the judge actually knew.
Yeah.
On why she based that decision. I'm just saying that if it really went down the way that the defense is suggesting, then it would have been the easiest thing to just do as we suggested. Okay, so the following day on July 2nd, 2024, Attorney Jackson was contacted by a jury. Was this after the declaration of mistrial? Ms. Short, neither defense counsel nor the defendant consent. Yeah, we did. So Attorney Jackson was contacted by a juror in this matter, Juror A, who stated that she or he wished to inform him of the true results of the jury deliberations. Mind you, I've literally seen law tubers come up, oh no, they were 8-4 in favor of acquittal, and they had other numbers for it. So I don't know where those numbers came from. Maybe they came off of Reddit somewhere or someplace on, I don't know. But this is Attorney Jackson's accounting of it, which flies in the face of all of that. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty on count 1, the most serious second-degree murder. Juror A was emphatic that count 1 was off the table, and all 12 of the jurors were in agreement that she was not guilty of such crime, which makes logical sense, knowing how the evidence played out. But how do we prove that, I guess, is the question, that was actually the case. The jury also unanimously agreed that Karen Reed is not guilty of count 3, which I guess makes sense, because if she's not guilty of count 1, how could she have known that he was dead? Then how could she possibly leave the scene of a death and all of that? Now, count 2 included those lesser includeds of, oh, do I still have the screen up? I don't want to, well, it included lesser includeds that I think one of them was driving while intoxicated or something like that. We'll go over them in a minute.
Not sure.
Yeah.
I know it included manslaughter.
But I understand that the lesser includeds I could understand why they would be hung up on that. So another day later on July 3rd, Attorney Yannetti was contacted by 2 different individuals who had received information from 2 distinct jurors, jurors B and C. So we got 3, and mind you, there's 4 as far as we know as of today's date, both of whom were part of the deliberating jury in this case. Informant B sent Attorney Yannetti a screenshot that he had received from someone of text messages that intermediary B had received from jury B. And in that screenshot, jury B texted the following to intermediary. The jurors were on as a group text.
Yes.
So maybe that's a thing that could be proven. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose sick. I think they meant to say on accident. Informant C had been in contact with another individual, intermediary C, who was a coworker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent Attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding that Juror C revealed in the Zoom meeting. No consideration for murder two. Manslaughter started polling at 6-6, then ended deadlock. 4 no, 8 yes. Wow. They were 8-4, and so I guess that's where the 8-4 comes from, doesn't it? Yeah. Well, I guess F me. Don't I look like the asshole? I'm dunking on this YouTuber who I don't even know who it is. I've heard, I literally don't remember. I I watched a video where somebody said 8-4. This must have been where it came from.
Mhm.
I apologize for whoever that was. Interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Not necessarily. Goes back to the jury verdict slip that was all confusing. So they're saying the jury slip was confusing. I don't know. The one that I saw was not that confusing.
No, it
It
was
literally
not.
had check boxes, guilty or not guilty. What do you
Mhm.
think? And if confusion was the issue, then I think it would have
Additional
been.
instructions.
Yeah. Okay, so she should have been acquitted. I agree. Yes, the remaining charges were that they were hung on, and that instruction paper was very confusing. Interesting. So here's their argument. The jury's unanimous conclusion that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes reprosecution. And they go back to quoting case law that we kind of already went over. What constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of each offense charge. And they're quoting Commonwealth v. Babb. The mere presence or absence of check marks on a form is not dispositive. Here, the attached affidavits by attorneys Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Miss Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. See Ellen Jackson's affidavit. Juror A was emphatic that count 1 was off the table, and that all 12 jurors were in agreement that she was not guilty on such crime. And that would be the real big one. I think, what was the max on count 1? Wasn't it life or 25? I forget. I'm mixing up cases. I was going to say that there was like a minimum of 15, but I think I'm confusing that with a different case. That can't be right. David Yannetti affidavit, it was not guilty on second degree. No one thought she hit him on purpose or even thought she hit him on accident. No consideration for murder 2. All right, we already read that. Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported, okay, so this is instructive. A juror had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited reprosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. Why is he quoting that case then?
I know, it's the opposite.
Yeah, I hate. This is giving me like flashbacks to law school. Like I hate like when I have like something in my head and then he
Yeah.
starts quoting something
Yes.
and it's like, what did he? I don't get it. Did I miss something? Okay, so the juror. Do you ever have those dreams where it's like, oh, it's like the end of the semester and it's like finals week and I have this final, but I haven't been to this class the entire semester and I have no idea what is. I still have those dreams to this day.
Yes, I have some weird dreams about either missing an assignment, not being prepared for a test because I didn't go to the class, or
Yeah.
I didn't know that the test was on that day. I don't know why those dreams come. I saw the other day the reminder that I had graduated from law school. I think it was like I started. That when I started it was 14 years ago. Still, I have those dreams. I don't know why.
Those are the exact dreams I have. I have like a dream like I went to class the first day and then it just like effed off on it and just forgot about the class. Now it's finals week. It's like, holy shit, what was that class about? And then it's like I'm supposed to take the final. Anyway, okay, so the jury's deliberations had not yet concluded, and it went back to the jury room to deliberate further. Here, by contrast, the jurors' statements reflect a final determination. Okay, so the
There we
difference
go.
is final determination. That persisted through the end of deliberations. I guess the question is, can you corroborate that by a
Yeah.
post-judgment text message thread shared on social media with non-jurors? People embellish
I know.
all the time to their friends.
Mhm.
It's just the source of the evidence is not good, is all. So even assuming arguendo, which I use that word all the time, or I used to, and it got on people's nerves.
Yeah.
I just like the word. Even assuming arguendo and contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. So they're arguing for broader protection. So this is almost dead on arrival, but certainly going to be going to appellate courts. They're citing cases. All right. So their second point, reprosecution is independently barred because there was no manifest necessity to declare a mistrial. The double, as we read, the manifest
Yes.
necessity is required. Double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, where a mistrial, hey, we literally quoted that case. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. Here, Ms. Reed did not consent to the declaration of a mistrial, and see his affidavit. Absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction. That's a stretch. That is a stretch of that case. It doesn't mean what he's wanting it to mean. The question is just simply, does double jeopardy attach procedurally if defendant was not given the opportunity to object prior to the judge declaring a mistrial? And then the question becomes, if the defense was ever afforded the opportunity to object, does it carry every single interaction with the judge going forward? Those are the questions in my mind. So absent defendant's consent. Okay, so the rule is rooted in the importance of the defendant of being able once and for all. I understand. You can't be tried twice for the same thing. You can't just keep holding something over your head. That's what he's going to say. So here the defense respectfully submits the lack of opportunity to be heard alone is dispositive. I don't know. What do you think about that argument? He's saying it's dispositive, meaning that it's automatic, that
Yeah.
which is not
It's
how that's going to go
like
down.
you said, it's a little bit of a stretch.
I mean, I understand why. Well, number one, he probably knows that this motion is going to get denied. He's preserving it
yes.
for appeal.
Mhm.
By the way, as this case is in appeal, and this could be an appeal for a couple of years, they cannot recharge her until the
That gets your soul.
appellate decision is resolved.
Mhm.
So there's that. Which leads us to the very real scenario that Karen Reed might be in her 50s before they retry this case.
Yes.
And as crazy as this case was with people not, butt dials and all of that, imagine how crazy it's going to be, 6 years down the road when everybody's like, you know what, man, do we have to? Or, I mean,
Like, we have to go through this again.
okay. The record is independently lacking on the second prong as it reflects to no careful consideration. I agree with this portion of it. So, all right, I missed something. I was going to skip things. This action was sudden, brief, and unexpected, neither preceded nor accompanied by a discussion with counsel. I agree because it literally was not. We saw the video. And he cites a case, Pickard v. Commonwealth, finding no manifest necessity where this is interesting. This is something. Finding no manifest necessity where no opportunity was given counsel to argue the propriety of the question of the necessity of a mistrial. That is highly relevant.
Yes.
Now we got some meat on the bone
Yes.
that we could chew on. So there is something there. Commonwealth v. Stewart. There's another case finding that no manifest necessity where trial judge first ruled that he was going to declare it a mistrial and then almost as an afterthought unenthusiastically asked whether counsel objected. That's interesting because they're citing the judge's lack of enthusiasm as a potential grounds for lack of finding of manifest necessity, which we've all seen is required in Massachusetts. So there's that. I gotta imagine though that the judge is going to vehemently defend herself in that that regard, of course.
Yes.
And all my other questions apply, which I'm not going to repeat because I don't like doing that. The record is independently lacking on the second prong as it reflects no careful consideration or alternatives to a mistrial. Here, there was one obvious alternative to simply ask the jury to specify the charge in which it was deadlocked. I agree. The very least that could have been done. Every trial, you know what? I've never had a trial that I've litigated go to a mistrial.
Okay.
The one time that it was close where I thought it might go to a mistrial, my client was acquitted.
Okay.
And so we won. But it was a thing, it was like, look, they've been deliberating for like 5 days. This is probably going to be a hung jury. They called us back and was like, oh, well, shit, we won.
Nice.
Let's bust out the Dalmore 25. I didn't have that kind of money back then. Okay. Had the court done so and the jury articulated its verdict consistent with the statements of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. I understand what he's arguing. So the Supreme Court's holding in Commonwealth v. Roth that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. They're talking about other stuff. Okay, so their third point is this. The defense is at least entitled to conduct a post-verdict inquiry. This is what I'm curious about. All right, so undersigned counsel did not initiate the communication with jurors A, B, and C, which resulted in the disclosure of information that is memorialized in counsel's affidavits that are appended to this motion. Should this court find that further factual development is required, the defense respectfully requests that the court conduct a voir dire of the jury and or an evidentiary hearing, a bit much, to substantiate the existence of an acquittal. Should the court seek the affidavit of each juror, the defendant asks for the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty of counts 1 and 3. So he's basically prescribing a potential remedy. So the Supreme Judicial Court has held that because of the importance of the issue. I'm boring myself reading this. You ever get that thing in law school where it's like, okay, I'm done reading old Greek language. And then like, but I can't because it's like finals week. I have to study for the bar. And then I literally have like this ADHD energy. And I would start like twirling in my chair like a helicopter. It's like, I want to not do this so bad, but I can't.
You have to. Yeah.
Yes. Okay. It is similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime in which he was. All right. I think we get what he's arguing. Conclusion: we want double jeopardy to apply. So his affidavit was this, and I'm going to read this one and the other one. I am a partner at law firm Worksman, Jackson, and Quinn. On Tuesday, July 2nd, I was contacted by Juror A based on my conversation with Juror A and that juror's description of who or she is, where he or she was seated, and certainly identifying information, name and occupation, disclosed during the voir dire process. I was able to positively identify which juror he or she was. Juror A told me that he or she was seeing inaccurate reports about the splits among the jurors related to the mistrial. Where did that information come from then? Mm-hmm. Because if it came from one of the jurors, then you got a problem, don't you? Then this motion is dead on arrival. Once we do what Jackson requested, then that juror is going to say, no, I thought she was guilty on second degree. And then it's like, okay, well, this was a big waste of time, wasn't it? That's a big deal. Okay, so Juror A told me she was inaccurate reports. Okay, Juror A stated that he or she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. Juror A indicated that he or she believes it important to disclose such results because he or she believes that those results significantly impact Ms. Reed's rights. Have you ever done a jury trial and then talked to the jury afterwards?
Not really.
It's fascinating to do that, man. The jurors get hung up on such crazy things. I had one juror literally tell me that, I just thought that the other attorney was an asshole.
Oh yeah.
And you made a lot more sense, and that guy was a dick. I was not believing anything that he said, and that's why he ruled in my favor, because he kind of asked for feedback and stuff.
I mean, I've seen documentaries where they interview the jurors after trial, and it's interesting to say like how they base their decisions and why they were thinking what they were thinking. Sometimes it's like, really?
I've heard stories where one juror was like, I went to the restroom and happened to run into a defense counsel there, and I saw him use the restroom and not wash his hands. And I was like, you know what? That's disgusting.
Mhm.
I'm not believing anything that he says, and I'm voting for guilt no matter what. Which is an extreme example, but
It is.
that's literally a thing that happened.
Mhm.
Okay, so Juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count one. Juror A was emphatic that count one second-degree murder was off the table, and all 12 of the jurors were in agreement that she was not guilty of such crime. Juror A told me that shortly following that determination regarding count one, the jury was also unanimously agreed that Karen Reed was not guilty in count three. On July 1, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. It should have been, I've never been involved in a trial where notes from the jury was not presented to me ahead of time.
Mhm.
And even if, because it's hard to do that when you're waiting a verdict on a trial, you literally are instructed, at least in my jurisdiction, to be within 15 minutes of the court at all time. And so you're just kind of hanging out like a
Around,
Starbucks.
yeah.
And then, they say, okay, you've been summoned to the court. The jurors have a question. And then before you ever get there, they will give you a document. This is the question. And then you have a chance to consider. And then they hold a hearing. And then that's how they do it. So it's significant because number one, you need time as a attorney to process what the juror is asking, to consider whether or not we're going to object or recommend certain things or request certain things. But to do it and just read it in open court and then just make a decision
Right there.
is kind of out of bounds.
Mhm.
It's not illegal, but it just seems like you shouldn't do that. But it's not against the law. I mean, I guess she was well entitled to do that. It just, Okay, so once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. I wonder if Jackson at that point was going to object and then stopped himself, knowing that he was going to make this motion just in case.
Maybe.
Because he wanted the mistrial,
Mhm.
because that was going to be like a victory of sorts, but then he wanted the ability to raise this issue
Mhm.
and then delay the filing of new charges for a number of years, highly discouraging the Commonwealth from bringing new charges in the future. I wonder if this was like just a thing that, because he knew that he could have objected. It's like, Your
Mhm.
Honor, objection?
Mhm.
There's no chance that he didn't know that.
Yeah.
My nervous energy would not allow me to not object. It just wouldn't. Oh, man. All right. So neither Ms. Reed nor the counsel consented to the entry of the mistrial. Defense counsel was denied the opportunity to request that the court inquire on which counts the jury may have been deadlocked. Nor did the court on its own inquire of the jury foreperson on which counts the jury was at an impasse. Again, it's important to understand that the judge didn't have to do any of that. Had the court so inquired, it appears clear that not guilty verdicts would have been recorded for counts 1 and 3. The prosecution would disagree, because all it takes is one to disagree, and then they get to retry the case. And that was the extent of his. Now let's read the other one. No, I don't want to save. Okay. Ren says, bro threw an ADHD tantrum. I feel like I did that the other day when I was going on about the counsel was literally like, Your Honor, we don't have her BAC. He's like, Your Honor, I don't need her BAC. That lady was properly blitzed. There's no sane person that would ever conclude that she was not intoxicated
Mhm.
at an extreme level. Bullshit. I almost said bullshit.
Almost.
Okay. Where is my notes? Okay, so I did that one. Here's the supplements. All right, cool. This one's on Reddit, so I don't have to do any special tricks. From now on, I'm just going to take the Reddit links rather than try to be professional and download the actual PDF. And this is way easier. Okay. So screen shared. So this is a supplemental affidavit. This was filed on July 10th, a couple of days ago. He says the same thing. So now he's bringing up Juror D. Based on my conversation with Juror D and that juror's description of who she was, I was able to okay, Juror D told me that he decided to reach out because he was uncomfortable with how a trial ended. He said that the last day of trial was a whirlwind. Everything happened fast. He recounted that, I'm just going to say his perspective. It could be a her. Oh, shit, I just screwed something up. How do I zoom back in on that? Damn it. No, I just got to read this small. Oh, man. All right, I'm just gonna roll with it. All right, so he was uncomfortable with how it ended. He said that the last day of trial was a whirlwind. He recounted that his perspective was that the jury was brought into the courtroom. The note was read, his trial was declared, and the jury was then rushed out of the courtroom following a brief meeting with the judge. The next thing they all knew, the jury was on the bus. He described the end of the trial as very confusing. Juror D said that it was very troubling that the entire case ended without the jury being asked about each count, especially counts 1 and 3. Jury D explained that the jury reached not guilty on counts 1 and 3, and the disagreement was solely on count 2. Juror D said that the jury was actually disgusting, telling the judge that they had agreed unanimously on guilty verdicts or not guilty verdicts for counts 1 and 3, but they were not sure if they were allowed to say so. That is infuriating. If that's true, it's infuriating. And again, all it takes is one, and then it's no longer a thing. Juror D said that the jury believed that they were compelled to come to a resolution on all counts before, which is really important because they need to know that they didn't have to agree on every single count to avoid a mistrial.
Now, it kind of makes sense what, I don't know, I don't remember who it was that mentioned that they were confused about the forms, but I remember that you mentioned they were confused about the instructions on the form. So maybe the instructions didn't include the option of finding, like acquitting her from on
That's
some
reasonable.
charges and not on another one.
I don't know if you've ever had to do this before, but when I was working for the DA's office, as like basically a paralegal, because I was still in law school, I was interning at the DA's office. One of my big jobs was I had to like write jury instructions. And it was like, this is confusing as F to me. Like, how are they going to figure this out? And again, I was like a second year law student, so I was basically a lawyer in utero. It was wild. They actually had me arguing cases. Did you ever get to do that? Like when you're in law school, not even an attorney, but you're supervised by the attorney, like arguing motions. That was really scary. Nowadays, it's just like, I could do it in my sleep. But back then, it was like calling my mom, I'm about to argue the big case. And it was like literally like a bail hearing.
Something super simple.
Okay, so once the case is over, she remained very okay. After the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen on counts 1 and 3? No one ever asked about those counts. Juror D stated that once the case was over, she remained very uncomfortable with the result. She reiterated it did not feel right. She said that part of her discomfort was that she knew that the jury had reached verdicts on 2 counts. That's a big deal, man. That's a huge deal. And then it begs the question, how much instruction did the jury actually receive if those were their questions? Every jury trial I've ever been a part of, the judge has gone out of their way to make the jury feel comfortable and not confused and all of these things. I don't know, man. It's infuriating on those grounds, but it's infuriating because it's so legally difficult to do what Jackson is asking. Even if, he's right, it's not that difficult for the appellate court to say, yeah, well, whatever, they could retry her anyway. What's the harm? And honestly, they're probably just going to fall back on that. It's the easiest thing to do. It's infuriating. So I inquired whether her opinion, other jurors would agree and acknowledge that not guilty verdicts were reached on counts 1 and 3. Juror D, without hesitation, said in substance, every one of us will agree and acknowledge that we found Karen not guilty of counts 1 and 3 because that's what happened. Okay. All it takes is one, right?
Yes.
So I wonder if all 12 jurors were to come and like write affidavits like, yeah,
Right,
informal poll here, but I would have said not guilty on 1 and 3. Then I think that it's an easier case. What's the likelihood of that happening though? Slim to none. Juror D reiterated that she believes that it would be unjust for Karen Reed to be retried on either count 1 or count 3 because the jury already unanimously found her not guilty of those charges. Juror D further stated that if necessary, she would agree to testify in order to explain to the court that the jury unanimously reached not guilty verdicts. Okay. My question then just is simply, without representation from all 12 jurors, how do we get there? What if somebody just wants to F off to the mountains because they're sick of it all and they don't even know any of this is happening? And because we can't get their opinions, we cannot proceed any further. So, them are the stakes, man. Them are the stakes. Hey, what was that noise? Dominic, did I miss something? Okay.
It was like a little chime.
Yeah. Okay. So that's where we're at with the Karen Reed mistrial. Where do we go from here? I actually don't know. Obviously they're gonna have to make a ruling on the motion. I don't know what's going on behind the scenes to either corroborate Jackson's affidavit or Yanetti's affidavit. He wrote one too. I'm not gonna read it because we're already an hour and a half in. Hour 45 minutes in. There's not really a clear-cut legal procedure or requirement for the jurors to be making themselves available without, I guess, a subpoena. Is the subpoena even legal under these circumstances? I'm not sure. In Massachusetts, I'm not sure. It's going to be difficult. There's a lot of things. It's readily apparent to me that there's a lot of things that could have happened that didn't happen. And should a mistrial have been declared? I obviously thought no. It makes all the sense in the world that this judge would have just pulled the juror. All right, what are we deadlocked on? What's the issue? You guys have had a weekend, and they were only deliberating for like an hour before she just declared, you know what? I think we're just going to be done. I'm not going to make you guys compromise on your morals. She took the juror's note at face value and made certain decisions that is going to create probably 3 to 4 years of additional litigation for no reason. When she could have just asked the jurors, hey, what do you think on counts 1 and 3? And then if the acquittals were on 1 and 3, is the Commonwealth really going to be pursuing her strictly on the basis of count 2? I don't know. Maybe they would have. But them are the stakes. And that's all we have really for that. Final thoughts on the Karen Reed situation right now, Ileana. What do you think?
I just really want to know what the decision is going to be. Other than that, we're kind of stuck. It's going to be a lot of time.
Yeah, I think Ileana needs a sandwich. So I think here's what we're going to do. We're going to wrap up this live, and we're going to go to the other live, Family Law After Dark. If y'all haven't, hey Dominic, is the Patreon have the link to the thing? You guys, we're going to get you the Family Law After Dark link right now. If you're a Patreon subscriber, Dominic's going to be posting that for our subscribers now. If you're not subscribed to the Patreon because of whatever, number one, Dominic really needs to make money. So he would really appreciate it if y'all would go down there, and we'll call it the Dominic Fund. Go subscribe to at least the lowest form of the Patreon membership. What do you get with that? You get all kinds of exclusive content, our movie reviews that we're going to be started. You get to see Rengery get dunked on in our first and initial tilted court. She tried to argue in favor of Laura Owens.
Oh, okay.
And her argument was that what was happening to Laura amounted to cyberbullying, in which case she got sufficiently dunked on. When I argued the opposite way, But full credit to Rendery, because she did an amazing job being a prospective law student, and stepping into that arena. She was kind of outgunned, but she made a valiant effort, and she's going to try it again at some point really soon. Ren says, monetizing on my dunking is heavy. It is heavy, Rendery, but she was. Okay, Dominic is setting up the link right now to the Family Law After Dark. So, folks, when we sign off here, go to the Patreon, get that link, and then we're going to resume with Family Law After Dark. For those paid members that want to participate in the Patreon, let me know, or let Dominic know, or drop a line in the Discord, and we'll get you a link, and then you guys could chime in. And that would be, well, that would be a thing, wouldn't it? Is everything set up with the? All right, folks. I love you lots. And by the way, next week there was an you know what? Just for shits and giggles, we had a comment on our Micah Miller coverage. You remember her?
Yes.
The AI girl, not the AI girl, but the AI calling all. So there was this comment that well, it didn't piss me off, it just amused me. But I was already planning on us revisiting the Michael Miller case to see the new developments in that, because I wanted to see if there's more information that came out that would corroborate whether or not this was an AI call, or whether or not there was something more nefarious going on with the Michael Miller case, or if it really was just a suicide. There's been developments. We're going to be covering that next week. But in the meantime, Dominic had clipped up one of our show from like May 18th or whenever it was. And this one comment came through, and I wanted to read it because it was amusing. Ooh.
Scare me. Oh my God.
So this was the comment. It comes from, you know what? I'm going to share my screen with you folks because I'm already here. Why not? Here it is. All right. So there was this comment by Lulu Loveberry 4161. And she says this. So my question continues to be, why cover these cases when you're not willing to use your critical thinking skills or your research skills to inform your subscribers? Hey, Eliana, you don't really read the comments, huh?
I don't.
So you don't get to see all of this this stuff?
I don't need to.
Well, she says, we're not willing to use our critical thinking skills or our research skills to inform our subscribers. What I don't think that Lulu Berry realized is that this was from a clip from like 2 months ago, and that we were like going off of available information at the time, and all of these conspiracy theories that have developed were not really a thing yet. And so she's like trying to dunk on us for not doing our research. But this is what she said. She says, I unsubbed a long time ago, but she just watched this video and commented on our latest drop. So there's that. Because it always hurts me to hear smart people say dumb things. If you had done your research, you would have found that Micah used the phrase kill myself once before in a recorded video during a trip to Africa. You know why I didn't know that? Because that wasn't a thing back on May 18th when we were researching the case. We just took the stuff that was from law enforcement that they had released. True Grizzly Crimes, who is basically the authority of internet sleuthing that I'm aware of, she's the best out there, was not privy to all of this. And so all of this was very new. So she says, the reason this matters is because if you watch and listen to that recording, you'll see Micah use her deep Southern drawl. So her natural, unconscious, authentic speech pattern is to pronounce this phrase as kill myself. The AI generated recording that fooled you. We've been fooled, Eliana.
Okay.
You are uncritical mind. Okay, you can't try to dunk on me and then write like that, for one.
Yes.
Come on, man. I mean, I feel like she's probably 3 or 4 whiskey double neats in at this point, but you can't write this way and then try to dunk on me for being uncritical, is all I'm saying. So her natural the AI generated recording that fooled you are uncritical mind. It's literally what she wrote.
Okay.
Has her pronounce this phrase as Northeasterner would. Now, using the login you were supposed to learn in law school, I have no idea what she's talking about.
What?
Tell me who puts on a fake accent to call 911 to alert them of their impending unaliving. I have to really digest that question to even know what she's really asking.
Mm-hmm.
I honestly don't know what she's asking. That 911 has her assuming that I assume that this is a she, because there's a dress,
Mm-hmm.
a cartoon of a dress. That 911 has her using an accent that is not her unforced speech pattern. You know what would have been really good if you and I had known what Micah Miller's speech pattern was beforehand, to maybe offer those thoughts on that video when we did it.
Yes, maybe.
But you know why we didn't? Because it was just a thing, just dropped at that time.
Mm-hmm.
But hey, she says accents are not the type of things one switches to and from according to one's move. And you know what's sad?
I
I
have
would
to disagree with that.
I would also disagree with that.
I can change, at least in Spanish, I can change my accent very quickly, and I do it automatically when I'm speaking to clients and when I'm speaking to my family. And sometimes people don't know where I'm from because they can't tell.
You know what else happens?
Mhm.
When I get when I get really emotionally excited,
Mhm.
anger, happiness, comedy, whatever.
Mhm.
They say that I start to talk with like a southern drawl myself.
Really?
I don't know. People say that. And it obviously shifts with my mood. And so there is that. But I'm going with her theory. So the 911 recording might as well had Micah using a Puerto Rican accent. Did she sound Puerto Rican to you?
What? No.
This person, I'm convinced, was on a drunken rant when she left this.
No.
Or a British accent during a deeply traumatic event. Conversely, imagine someone with a Puerto Rican accent calling 911 to announce they are unaliving themselves in a Russian or an Argentine accent. What is she on about, man?
Well,
A lot of our followers, including Lethal Lauren. You know Lauren Nighty? Lauren's awesome. She's I've done live streams with her. She has her own YouTube channel. She's really, really good. She's like 31 years old. I think that she works as like a psychologist. But she wrote to this person, "Hey, I got something for you. This link may be very helpful. It's a list of productive ways to fill out your time." And then it's like, you could read, you could watch a movie, you could meditate, you could, all these different things. I had responded to this lady's like, for all your critical thought that you put into this post, you fail to realize that this was a clip from a show produced not long after the incident occurred. And before all of the theories that you just outlined had been developed, you further failed to realize that I had been planning a future live stream addressing these theories. I'm pretty sure I talked about that or not. I don't know.
I don't know.
I cut my own self off. How do I even get into the rest of it? I don't know. I said something. Once again, my only point is, I think hey, whoever that was, she used to be a subscriber. She's no longer a subscriber. She really liked her Christopher Watts mock cross-examination that I really needed you for, because I wanted you to be the judge, because I was forced to make my own objections and rule on my own objections. And you've already known.
I know how that goes.
Seen how that's going to go. Objection. Overruled. But you're the judge. Bullshit. I'm doing it anyway. It's just how it is. All right.
And I might have to add the Puerto Rican and the Argentinian accent in English is probably going to be the same.
Your Argentine accent?
No, I mean, in Spanish, you can tell the difference between Argentinian and Puerto Rican accent, but those two
I would not be able to tell the difference between
it would
those
probably
two
be the
things.
same because Spanish.
Micah Miller's not even Puerto Rican, or
I know. I don't know.
I think she was just talking shit. Here's my note to her. It was just like, look, I have one rule. And this, I really do just have one rule.
Yeah.
In our community, which is growing and awesome. Our people are amazing. We got prospective law students in our group. We got retired folks. We got people that are living their lives and, dealing with their personal issues. But everybody in our community is very respectful of everybody else. My only rule is this: don't be a dick. That's all. Just don't be an asshole. Like, it's the easiest thing to do. I said, I haven't looked at this case in 2 months, rather than saying, well, did you consider all these other things? Which I haven't, because back in mid-May, they were not a thing. Inviting discussion, exchange of ideas. You wanted to try demonstrating how much smarter you were than everybody else from way over there. Oh, she was getting an argument with some of our other commenters, and she's like, I didn't mean anything by it. She said, I said that he was smart. It's like, you know, I've been smart for a long time and I don't really need that validation, but thanks for the compliment and all. But you knew what you were doing. You knew you were being a dick. I didn't, you know, just be nice. That's all. Just come up, have a drink. We can all hug it out. We're still friends, which is kind of how I treat everybody, man. It's like, hey, you could disagree with me. You could think that I'm being uncritical. You could think that I'm
You can agree to disagree.
yeah, that's all fair game. Oh, that was the Discord chime, wasn't it? That's the chime that I'm hearing. I'm just saying, just be nice. That's all. All right, folks, I got to wrap this up. We've been going for a couple of hours now. Let's do Family Law After Dark. Folks, go on to the Patreon. If you don't have the link to the Patreon, what's the link to the Patreon, Dominic?
I put it in chat, but I put it in the Discord as well.
Okay. Dominic has linked it in the chat and he's linking it in the Discord as well. Go to the Patreon, click on the link. It's unlisted on the YouTube page. It's strictly for the Patreon subscribers. We will see you guys next week. We're going to be covering more of some Micah Miller. For the rest of you, in about 5 minutes, we're going to be doing some Family Law After Dark or so. I got to feed Ileana. We love you all.
Bye.
Bye-bye.